Welcome to this explainer. Today, we're stripping away the purely traditional views of Muslim marriage and looking at it through a really fascinating legal lens. We are talking about the nikah, not just as a ceremony, but as a highly sophisticated, living civil contract. Here's our roadmap for the life cycle of this contract. We'll start with roots and reforms, hit the contract essentials, look at mahar as a financial safeguard, explore rights and remedies, unpack the pathways to divorce, and finally, wrap up with post-marriage regulations. Let's jump right in. Okay, Section 1, Roots and Reforms. To really grasp this legal structure, we actually need to look at the historical landscape it replaced. Think about pre-Islamic Arabian society. It was, frankly, chaotic for family stability. We're talking unrestricted polygamy, temporary unions, and widespread exploitation with basically zero rights for women. So the Islamic reforms, they were a massive paradigm shift. The Quran literally transformed marriage into a regulated institution, heavily focused on family responsibility and, this is crucial, the actual recognition and protection of women's rights. The renowned jurist Amir Ali really hit the nail on the head here. He framed nikah fundamentally as a legally binding civil contract. Yes, it obviously carries deep religious and moral weight. It's highly encouraged as a social duty. But unlike ancient Hindu law, for example, which treats marriage as a pure, unbreakable sacrament, nikah is fundamentally and legally contractual. Moving on to Section 2, the contract essentials. What's wild here is just how much entering a nikah mirrors signing a modern corporate agreement. For this contract to be perfectly valid, or sahih, it demands some absolute essentials. First off, competency. Both parties need to be of sound mind and have attained puberty. Second, ijab and qabul, a clear proposal and immediate acceptance. And here's the really fascinating legal catch. Both that proposal and the acceptance have to happen in the exact same meeting. If you propose in one setting and they accept in another, deal's off, it's invalid. Throw in absolute free consent and a lawful object and boom, you've got a binding agreement. Now, the fine print does depend on the specific Islamic school of thought. Take the witness requirements, for example. Under Sunni law, a valid contract strictly requires either 2 male witnesses or 1 male and 2 female witnesses present. But jump over to Shia law, and witnesses actually aren't strictly essential to the validity of the contract itself. So how well did you follow those rules? Depending on that, Islamic law sorts marriages into 4 distinct legal buckets. First is sahih, completely valid, you get full legal rights. Then there's batil, absolutely void from day one. Think marrying a prohibited relative, just no way. Third is fasid, or irregular. It's kind of like having a technical glitch, like missing a witness. It doesn't instantly void the whole shebang, and you can often fix the defect. And finally, muta, which is a temporary fixed-duration marriage with a set dower, primarily recognized under Shia law. All right, Section 3, mehr, the financial safeguard. This is where we see how the contract builds in some incredibly robust financial protections for the wife. Mahr, or dower, is such a critical element. It's money or property the husband legally agrees to pay the wife. Let's clear up a massive misconception right now. This is absolutely not a bride price. Not at all. It's a mandatory financial safeguard given as a mark of respect, and it becomes the exclusive, unquestionable property of the wife. Get this. Even if the contract completely forgets to mention it, the law says she is still legally entitled to it. It's that fundamental. And the contract handles this payout in very specific ways. Dower can be specified, meaning you write the exact dollar amount right into the agreement, or proper, where a court actually calculates a reasonable sum based on the wife's social status. It's also strictly scheduled. It can be prompt, meaning payable immediately on demand, or deferred, meaning it's held back and paid out when the marriage ends, whether through divorce or the husband passing away. But what if the husband doesn't pay? Well, the wife holds incredible legal leverage. Before consummation, she has the absolute right to refuse cohabitation until that prompt dower is paid in full, and she can flat out sue for recovery. And amazingly, a widow has what's called the right of retention. This means she can lawfully hold on to her deceased husband's property until her dower debt is fully settled by his estate. Talk about a built-in safety net. That brings us to Section 4, Rights, Remedies, and Protections. Because just like any complex civil agreement, this contract has to handle disputes. Which brings up a really interesting scenario regarding free consent. We said consent was essential, right?
So what happens if the parties were legally minors when a guardian signed the contract on their behalf?
Well, Islamic law provides a built-in escape hatch for this exact situation. It's called khayr ul-bulugh, or the option of puberty. Basically, if a minor was given in marriage by a guardian, especially someone other than their father or grandfather, they have the absolute right to legally rip up that contract once they come of age. As long as they do it before consummation, they can walk away. I think it perfectly illustrates the system's strict commitment to ultimate free consent. Furthermore, the contract binds both parties to mutual duties. If one spouse just packs up and abandons the other without a lawful reason, the aggrieved party can actually sue for the restitution of conjugal rights, which is essentially a court order to resume cohabitation. But wait, the law provides strong defenses here. A spouse can entirely defeat this claim if they prove cruelty, or, circling back to our financial safeguards, if that prompt dower hasn't been paid. Okay, Section 5. Pathways to divorce. Unlike some traditional systems where marriage is practically an unbreakable chain, nikah recognizes that, hey, sometimes contracts just have to end.
The husband does have a right to unilateral repudiation, known as talaq, but it is highly regulated. The most approved Quranic form is asin, which is a single pronouncement followed by a strict waiting period. Then you have hasan, which is 3 pronouncements spread over successive periods. And finally, there's talaq ul bid'at, or the instant triple talaq. Now, while historically recognized among Sunnis, it is worth noting that the Indian Supreme Court recently examined this exact practice in the Shayara Bano case and formally declared instant triple talaq unconstitutional.
But the husband definitely isn't the only one holding the keys to termination. Women have distinct pathways too. There's khula, which is a divorce initiated by the wife, usually by offering to give up her dower in exchange for the husband's consent. There's mubarat, which is a mutual, agreed-upon dissolution. And beyond traditional law, modern statutes like the Dissolution of Muslim Marriages Act of 1939 give women powerful statutory grounds to demand a court divorce. We're talking situations where the husband has been missing for 4 years, fails to provide maintenance for 2, or treats her with cruelty. Our final stop, Section 6, Post-Marriage Regulations. Because tearing up the contract doesn't mean all obligations instantly vanish into thin air. Following a dissolution, whether by divorce or death, women are required to observe a mandatory cooling-off period called iddat. The primary rationale here is super practical. It's to determine if she's pregnant, completely preventing any confusion of parentage and strictly protecting the child's lineage. Plus, in cases of a revocable divorce, it provides a dedicated window where the couple could potentially reconcile. The exact duration of this iddat period is strictly calculated based on exactly how the contract ended. For a standard divorce, it's generally 3 menstrual cycles. If the marriage ends because the husband passes away, widowhood requires a period of 4 months and 10 days. And if the woman happens to be pregnant when the marriage ends, the iddat period automatically extends right up until the delivery of the child. Finally, to preserve the family structure and social order after a contract ends, Islamic law establishes some strict rules on who you can lawfully marry next. Absolute prohibitions mean you can literally never marry certain close blood relatives, in-laws, or foster relations. Then there are relative prohibitions, which are temporary. For instance, a man cannot lawfully marry a woman who is currently observing her iddat period, nor can he take a 5th wife if he already has 4 valid marriage contracts active at the exact same time. So, we've seen how the nikah is built on these incredibly firm foundations of mutual consent, rigorous financial security, and highly specific enforceable remedies for both parties. It's a legal structure that has successfully balanced the personal, the financial, and the spiritual for well over a millennium. As we wrap up, it leaves us with a pretty provocative question. How might these intricate, centuries-old contractual frameworks challenge our modern assumptions about family law today? And really, what can modern civil agreements learn from a system where financial safeguards and contract termination rules are built right in from day one? Thanks so much for joining me on this explainer.